That's good, YouTube. Back at it. American ROX. I want to say shout out to my subscribers. Thanks for subscribing. Keep sharing content. Keep liking the content. Appreciate it. Um, Tonight I'm not gonna be too long. Just gonna share a little bit of you know, I've been doing some research lately about treaties and you know like civil rights. I realize that um it all correlates, and also the timeline as well. Like when you look at the timeline, you realize like one thing led to the next, and this is where we're at right now. Um, People who have been through so much abuse in regards of our identity. Um, it's just an all around identity crisis. You know what I'm saying. So I'm gonna share my screen for a little bit, and I'm gonna get to this book called Aboriginal Races in North America. Um, so I'm gonna share a little bit. Yeah. So I'm gonna be reading from this book, Aboriginal Races in America, and I'm gonna just show it to you that it was all like it was all planned out. You know what I'm saying? And you're gonna see what I mean when I say that whenever you sign treaties, you actually give up your Aboriginal title to the land. All right. First of all, before I start reading this book here, I'm gonna read to you what Aboriginal title is. Okay? I'm gonna I'm gonna Google it for you. So I'm gonna show you what those treaties are all like most of them was just a plot, okay, to usurp your identity and trade places with you. Okay, I'm gonna show you real quick. I'm gonna break it down. Right, I'm gonna start so you could get a basic understanding of the concept of what I'm trying to show you. Okay, so Aboriginal title is a common law doctrine that land rights of indigenous peoples customary tenure persists after the assumption of sovereignty under under settler colonialism. So customary tenure is land which is owned by indigenous community and administered in accordance with their customs, as opposed to statutory tenure, usually introduced during the colonial periods. Common ownership is one form of customary land ownership. So what it's saying is a statutory. There's a bit difference between your customs, according to your customs, your own customs, and there's a difference between statutory. Now, that's what the United States is. They hold the the land in trust. All of these corporations in the Americas hold the land in trust. This is why they um rape the land. They take the resources, they sell it, do as they like because they hold it in trust. But it's supposed to be for your benefit, for our benefit. But for some reason, that's not the case. You know what I'm saying, you know, they create these fake reservations because they're all fake. How can a foreigner come to your house and put you in a little in one room and say, okay, that's where you're gonna stay, and I'll take the whole house. So they come in your house, put you in a room, and say that's your home, and they take the whole house from you. Does that make sense? I'm saying, gotta think, man. So what I'm saying is that these treaties, what was the intent? You know what I'm saying? What was the purpose? What was the plan? Who was behind these treaties? Who signed it? Who approved of it? You know what I'm saying? Were they real? You know what I mean? Were they valid? So all these questions pops up. You know what I'm saying? But anyway, customary tenure persists after assumption of sovereignty and settler colonialism. The requirements of proof for recognition of Aboriginal title, content of title. I mean, who you got to prove to? Who you gonna prove to? You know what I'm saying? Requirements of proof. Why would you need to prove that you've been here way before a foreigner? They need to prove who they are, not us, not you. You know, the Aboriginal or the original or the Indian. You know what I'm saying? The first people of the land. You know what I'm saying? The autochthon. So what I'm saying is that it was all trickery, man. The content of Aboriginal title, the methods of extinguishing Aboriginal title, and the availability of compensation in the case of extinguishment vary significantly by jurisdiction. Nearly all jurisdictions are in agreement that Aboriginal title is inalienable. This word inalienable is also a tricky word. I'm saying in property law, alienation is the voluntary act of an owner of property disposing of the property. You know what I'm saying? While alienable is the capacity for a piece of property for or a property right to be sold or otherwise transferred from one party to to another. So it's all trickery, man, and that it may be held either individually or collectively. So all you indigenous people who have mortgages on your house, I'm saying you gotta do some research. You know, you know, claim claim who you are. You know, do your genealogy, claim who you are, and then put that put your property up under your jurisdiction as far as who you are by your identity. You know what I'm saying? Does it say individually or collectively? Collectively mean a tribal or just be you. You know, Aboriginal title was first acknowledged in the early 19th century in decisions in which indigenous people were not a party. Significant Aboriginal title litigation resulted in victories for indigenous peoples did not arise until recent decades. The majority of court cases have been litigated in Australia, Canada, New Zealand, and the United States. Aboriginal title is an important area of comparative law. That is a study of differences and similarities between the law of different countries. More specifically, it involves the study of different legal systems. Okay. With the many cases being cited as persuasive authority across jurisdiction, many commentators believe that the doctrine is applicable in all common law legal systems. Aboriginal title is also referred to as indigenous title, native title, particularly in Australia, original Indian title, particularly in the United States, customary title, particularly in New Zealand. Aboriginal title jurisprudence is related to indigenous rights, influencing and influenced by non-land issues, such as whether the government owes a fiduciary duty. See, so the United States has a fiduciary duty to the Indians. They hold the land in a trust, so they are the fiduciary. Okay, they they should always make sure the Indian is taken care of. Okay, to indigenous peoples. While the judge-made doctrine arises from customary international law, it has been codified nationally by legislative treaties and constitutions. So See the word treaties right here again. So what I'm saying is that they use these things to take land from the people through trickery, right? And you gotta know international law as well. Okay, I'm gonna show you. I'm gonna show what I'm talking about. Okay, all right. So this is the Aboriginal races in North America, right? This is a book. I'm gonna show you on page. Page is this? Oh shit. Wrong one. Yeah, I'm gonna show you on page. Um, so page 411, right? I'll read down here for you. Shit, I'm all the way back up. Okay, so let's get down here. So it's gonna be very short. I'm gonna show you what I'm talking about. Read from here. The next event of considerable, considerable moment in the history of the Seminoles is the Treaty of this affair. I am able to speak in the language of the principal agent in it, of the whites. The individual to whom I refer, General Wiley Thompson, will be particularly noticed here. After from the melancholy he met in the progress of this war, I have in previous chapters spoken of the treaty at Mullery Creek, but I have in a previous chapter, no, but before going into the particulars of that Payne's Landing Treaty, it will be necessary to make a few additional observations. Indians who consented, okay, who consented to that treaty, by such consent agreed to come under protection of the United States to give up their possessions and remove certain restricted boundaries in the territory, the extreme point of which was not to near to be nearer than 15 miles to the sea coast of the Gulf of Mexico. Okay, you see, they say the trick is so you have to give up the land to come under the protection of the United States. You give up your possession, so you come under them, right? You give up your possession. This is where they have the trust. But check this out. I'm gonna read from here. Right? This is from the Bouvier's dictionary. Stay with me. I'm gonna show you something. I'm gonna try to pull this. Okay. Try to zoom the scene, but the computer slow. All right. So shit. All right. So Indian, the name of Aboriginal inhabitants of America. In general, Indians has no political rights in the United States. All right. Who had no political rights? So-called Negroes, right? They could not vote at the general elections for officers nor hold office. In New York, they were considered as citizens and not as aliens, owing allegiance to the government and entitled to its protection. Cherokee Nation in Georgia was a distinct community, right? Um, the title of the Indians to land was that of occupation merely, but could be divested only by purchase or conquest. Okay, so that's why they always have wars. Okay, no Indian nation or tribe within the United States shall be recognized as an independent nation with whom it may contract by treaty. So if you have a treaty, you have no sovereignty pretty much. Okay? It's saying you won't, Indian tribe that has a treaty won't be recognized as an independent nation, whom it has contracted a treaty. But priorities are not to be thereby impaired. By Act of March 3, 1885, any Indian committing certain crimes within any territory within or without an Indian reservation is subject to the laws of the territory and shall be tried in the same manner and be subject to the same penalties as other persons charged with the same crimes. And if such offense be committed within reservation in a state, he shall be subject to the same laws if it were committed within this exclusive jurisdiction of the United States. This act was held constitutional in uh, this case right here. The United States courts have jurisdiction of crimes committed by Indians within a reservation. So pretty much what I'm saying here, all these reservations are regulated by the United States. Okay? So if you have a treaty with the United States, you're pretty much a US citizen, pretty much. Put it that way. If you're a tribe, your so-called tribe have a so-called treaty. Right? They're saying you extinguish your Aboriginal title, extinguish your sovereignty, right? That's what they're saying because it said within the United States. Within. United States is only 10 square miles in DC. That's the United States. It doesn't exceed that. So you have to contract with the corporation, right? And when you contract with a corporation, the corporation doesn't see you as an independent nation anymore. Okay? Or the trustees of the corporation. So, as I said before, the only way to retain your status as being a true Aboriginal or Indian is to be not taxed. That's the original status of Indians, not taxed. If you come out of that status, you're just as everybody else, a slave, right? Okay? It said right here. Okay? Now I'm gonna go to Civil Rights Act. Martin Luther, right? He was fighting for civil rights, right? Okay, I'm gonna share what happened when he fight for civil rights. So this is the Title II Rights of Indians. For our purposes of this title, the term Indian tribe means any tribe, band, or other group of Indians subject to the jurisdiction of the United States and recognized as possessing powers of self-government. So what it is saying is that you're recognized as possessing powers of self-government, but they still have jurisdiction over what you can and cannot do. Okay? So powers of self-government means and includes all governmental powers possessed by an Indian tribe, executive, legislative, and judicial, and all offices, bodies, and tribunals by through which they are executed, including courts of Indian offenses, and Indian court means Indian tribal court or court of Indian offense. So pretty much when when Martin Luther said he's afraid he led his people into a burning house. This is what it was pretty much referring to, because you're already not taxed. So why would you want to be, why would you want to be equal to your oppressor or the colonizer? They're foreigners. Why would you want to be equal to them? You're already high on the land. You already have you already um self-governing. You know what I'm saying? You have all full autonomy. You gave it up for some civil rights. One moment. Be right back. Yeah, so that's what I'm saying, man. You gotta be not taxed, man. I'm saying to you, don't follow these other people out here, man. Please read, okay? You're gonna be jammed up, especially if you don't know how to be an executor over your state, which is your um quasi instrument called a birth certificate, or over all your persons or your papers. So I'm saying, because those are as persons, all those documents, those paperwork, there are persons, property. Okay, you have to um, learn how to control all those entities. All right. Peace to the chat. Peace to the chat. We're in the chat. Peace to you. Yeah. So I was just discussing about treaties, civil rights, all this stuff. It's a smoke screen, man. You want to keep your autonomy, stay not taxed, and just you know learn how to maneuver. Learn how to be executor. You know, copyright claim all your documents, and I'm saying your persons, which is the legal name. You know, what I'm saying, you could use that as a business. You know, be the controller, the holder of that name, and retain all your rights to be not taxed. Because not taxed is just mean you're not a subject of the colonial system, right? So this is all I wanted to just share with you guys, and I hope you read and start to analyze these terms. Get yourself a law dictionary, go to the law library, start to read more, understand what you're reading. Um, it's all trickery. You know what I'm saying? So I want to talk about. Peace out.